everyone. My name is Eva Klein. I'm an attorney with the ABA Center on Children and the Law, and I would like to welcome you to Money Matters, How Funding Changes Affect Legal Representation Quality. And I just want to tell you a little bit about how we are going to talk today about the assessment that we did. And I'm sorry because my screen is not moving. Oh, goodness. Okay, I'm really sorry. So again, my name is Eva Klein, and we are going to talk today about the assessment that the ABA Center on Children and the Law did in California with the funding from the Walter S. Johnson Foundation. So we want to thank our project officer, Yali Lincroft, and also with the assistance of the Judicial Council of California, who helped us in choosing our sites to study and in helping us understand more clearly the funding situation in California. And so what we are going to do today is, again, describe the report that we developed and the assessment, how it took place, give you some of the background on the funding changes and how we found we developed 3 findings and recommendations on how funding changes affect the quality of legal representation. And so what I'd like to do first is introduce our speakers. We have Prudence Beidler-Carr, who is the director of the ABA Center on Children and the Law, and Leslie Starr-Heimoff, who is the executive director of the Children's Law Center of California. And Prudence, I'm going to turn it over to you to talk a little bit about the Center on Children and the Law while I try to resolve this tech problem.
Sure, absolutely. Thank you, Eva. So I am going to give a little bit of grounding to just lay the groundwork for why the ABA was brought in to do this evaluation of attorney funding changes in the state of California. The Center on Children and the Law is an organization that operates very much as a nonprofit within the larger American Bar Association. So the larger ABA is essentially a trade association for legal professionals of about 400,000 members, which include judges, lawyers, paralegals, etc., in lots of different areas of the profession. And the Center on Children and the Law specifically is an organization within that that's focused on serving a mission of promoting access to justice for children and families. We're staffed with 16 people. Almost everyone on our staff is an attorney who comes from direct practice in the child welfare space, representing children, parents, or agencies in a variety of different jurisdictions around the country. And most of our work is similar to this project. Most of our work is grant funded. We do a lot of different projects in collaboration with national partners, state partners, and local partners around the country, focused on 2 overarching areas. The first is really working to improve legal representation, primarily in the child welfare field. And the second is working to improve the way that legal systems affect children and families. And a lot of that means looking at the intersection of child welfare and other legal systems like immigration, education, kin caregiving, and things like that. I apologize that I don't have the slide up, but I think that Claire can put in the chat the link that I'm going to speak about next, which is an infographic. And so if you can click on that in the chat, we have an infographic that we call the Child Welfare Legal Representation Infographic. And what this does is highlight sort of why we focus so much on the importance of legal representation in this field. So the easy answer as to why we focus so much on the importance of attorneys in child welfare is because we work for the ABA. But that's really not the story. The real reason that we focus on this area is because of the huge impact that high quality representation makes for improving access to justice for children and families in this space. And so if you look to the left, thank you, Eva. If you look to the left, that left column of the infographic highlights the benefits of high quality legal representation for all parties, and breaks down into those different areas information that has all been researched. So there's actually data and research backing up each of these points, which is that high quality representation protects parent and children rights, increases parties' participation in and out of court, improves all parties' perceptions of fairness, reduces delays in achieving permanency, and we'll talk about this at great length today, promotes tailored case plans and services, which makes sense because of the increased participation, improves frequency and timeliness of visitation and family time, empowers families and communities to keep children safe at home, informs better judicial decision-making by having active advocacy from all three parties, and saves jurisdictions money by reducing the time that children spend in care unnecessarily. And so the other piece of the puzzle that I wanted to sort of highlight is not just that question of why it's important to have high quality legal representation in this field, but how do you achieve quality? And that's really one of the main goals with the assessment that we're going to talk about today, and the opportunity that we had to look at funding in California. So if you look at that right part of the screen, those are quality hallmarks, many of which derive from ABA standards of representation that we've put together in collaboration with attorneys and judges and court improvement program staff from around the country over many years, that really look at sort of what are the criteria that make quality representation, so that we're not just talking about making sure that we have you know, an attorney appointed in a case, but making sure that the representation meets a standard of quality. Past research really does look at questions like what models of representation have an impact on outcomes for children and families, what types of criteria are necessary to meet these standards, et cetera. But what was really unusual with the opportunity that we had in California was that this was the first time that we had a chance to look at what is the impact of funding, of money, on affecting quality. That was really the question that we were asked to come in and look at, as Eva mentioned, from the Walter S. Johnson Foundation, which invited us to come do this assessment in the state of California. And the reason that it was so timely was because we were able to look at some significant changes in funding in a number of different sites in California between 2014 and 2018. And Eva's going to talk a little bit more about those details. But what became really particularly exciting, which I know many of you on this call already know, is that the timeliness of this evaluation of what funding does for quality of representation suddenly meant a lot more at the end of 2018, when the federal government made a change in the federal child welfare policy manual, opening up federal Title IV-E funding for the first time to support child and parent counsel in states around the country. And so all of a sudden, this question of what is the impact of funding on child welfare, on the quality of representation for children and parents, became something where we were not only evaluating the impact on California, but really helping to inform decision-making for agencies that now have that question about whether to draw down those additional resources. The other thing, which is on the less positive side, is that this evaluation, by looking both at sites where funding increased and sites where funding decreased, also provides some really important information right now in the time of the pandemic, when state budgets are looking at unprecedented cuts across the country, and really helps reinforce the message as to why it's important not to allow cuts to child and parent counsel funding among the difficult decisions that will need to be made, because ultimately those will have ramifications that far exceed the cost of the cuts. And so the bottom line with the report, as the title to the webinar indicates, is that what we discovered in doing this evaluation and assessment, which we were really grateful to have the opportunity to do in partnership with the state, is that money does matter. It matters a lot. Increases in funding matter, decreases in funding matter. But what we also discovered is that that's not the full story. And so we're going to use this time today to help explain kind of what those findings were. And also in each section that we talk about, we'll provide a little bit of context of how you, as practitioners in different jurisdictions around the country, can use this assessment to advocate for increases or stability in funding in your own jurisdiction.
Thank you, Prudence. And so I apologize again for my frozen screen, but one thing that I did want to do at the beginning was to get a sense of our audience and to ask you to please enter into the chat what state you are from so that we get a sense of what representation there is across the country. Clearly today we're talking specifically about California, but we would love to know who is listening and how we could maybe help you take the lessons from this assessment and apply it in your home states. And while you're doing that, I also want to make sure I mention to you in terms of engagement with the panelists, if you have questions as you're listening, if you'd like to type a question into the Q&A, we have definitely reserved some time at the end so that we can answer any questions that you have that come up as we are talking. And I see there are quite a number of you putting in your states, so thank you for that very much. And that's just great. So let me talk a little bit about the assessment background. And as we mentioned already, we were invited in by the Walter S. Johnson Foundation to take a look at some of the changes that were happening in California. And we were asked to come in as a neutral third party. And of course, we had to have the permission of the jurisdictions that we were working with in this assessment. But basically, there were changes in California, which is a county-run child welfare system, and the legal representation provided within those counties is based on contracts between the vendors and that particular county. And so the Judicial Council did look at how the funding for dependency counsel was allocated among the different counties and discovered that there were a lot of changes in shifting caseloads and in funding needs, and also that some of the counties had met what was seen as the need, the funding need, had met their funding need, might have been at 100% or even more, while other counties were only meeting about 50% or sometimes even less percentage of the funding need that they had. So the Judicial Council came up with a new funding methodology, got feedback from the field, and developed a reallocation plan to try to bring some equity in the funding so that all counties met the same percentage of need. And so that reallocation provided a great opportunity for us to come in and study or assess that impact of those reallocations. So when we talk about the ABA assessment period, we used 2014 as the baseline and then studied the changes over an additional 3 years. So that is the ABA assessment period. And we understand that there have been a lot of changes since then as well. But when we talk about the assessment, it is just during that time. And just to give you an idea of how that worked within specific sites, and I'm going to talk a little bit about how we selected those sites in a minute, but here you see between site A, which was a county that had an increase in funding, and site B, which was a county that had a decrease in funding, you can see the blue is the cumulative increase. So it starts at 0 and then either moves up or down, and then the red is the percentage of funding need met. So you can see that in site A, as funding increased, the percentage of need met also increased. And you can see in site B that they were well above 100% of their funding need met. And then as the funding decreases occurred over the next 3 years, they actually declined in the percentage of funding need met. So the goal was to have all counties at the same percentage of funding need met. So that does not mean that they were fully funded or even adequately funded, but that was the percentage of the funding need that they received. So how did we select our sites? So we used data on county funding reallocations, and we also tried very hard to weed out any other influences. So there might have been some counties that had some backfill from either their county board of supervisors or other funding sources, whether it be foundations or some other source. And so we did not use those sites. We also looked at community type. We wanted to make sure that we had some diversity in the type of community that we looked at. We wanted to make sure we had geographic diversity within the state as well. And we looked at the socioeconomic profile of the community, as well as the population demographics. And so those were sort of the criteria we used in picking counties that we would consider eligible. But then we also wanted to make sure that the data that we would need was available, and also that the counties themselves were willing to participate, because this was not a situation where we were coming in and demanding information from them. We were requesting them to please allow us in so that we could study this change and how it might be affecting the quality of legal representation. So as I mentioned, we had assessment sites that either received additional funding or lost funding. And so increased funding site A is a large, mostly urban site with an increase in funding. Our second site, B, was a decreased funding site. It was also a large, but mostly suburban county with a decrease in funding. And our decreased funding site, C, was a small, mostly rural county that also had a decrease. So the methodology that we used, this was an independent case study design. We looked at each county as a site, as a single case study. We were not comparing them to each other. And we did not go in, this was not a randomized controlled study the way much research is done. This was an assessment in a retrospective in our look at how the funding reallocations affected mostly, well, a lot of the information was a perceived effect on the quality of legal representation. So we collected data from 3 sources. We did use case management systems. In 2 of the sites, that information came from the legal services providers themselves, and in 1 of them, it came from the court. We also conducted site visits and interviews with the attorneys, judges, agency leadership, and several other stakeholders also in the child welfare system. And we also did attorney studies for each of the 3 sites. So based on those data sources, we analyzed the information that we received, and we came up with three findings and 4 recommendations. So our first key finding was that funding changes for child and parent counsel had a direct impact on several factors that affect representation quality, and these included attorney recruitment and retention, multidisciplinary legal practice, caseloads, workload per case, and case delays. So if you look at each of those, they primarily fall into 2 different categories. One is staffing and the other is time. So under staffing, we looked at attorney recruitment and retention. So that's really the ability to hire high quality attorneys and then retain them for the long term. Another was the multidisciplinary legal practice. And we found that in some sites, there was multidisciplinary legal practice, and in others there was a desire. For instance, one of the decreased funding sites had a desire to establish a multidisciplinary legal practice, but didn't have the funding sufficient to do that. Also looking at compensation levels, and the ability to recruit is directly also tied to compensation levels. It's a highly complex area of law, and having highly qualified attorneys compensated at an appropriate level is an important consideration. And then the other category was time, which really addressed caseloads and workloads and continuances. So caseloads certainly can be affected by increased funding in terms of increased number of staff or having more time to look at the different aspects of a case, more time for out-of-court advocacy, and more time to prepare for court hearings to meet some of those hallmarks or attributes of high-quality representation, and specifically more time to meet with clients. and of course continuances, and having supervisors or sufficient staff to cover hearings when an attorney can't make a specific hearing. Those can also be affected by the ability to, can be affected by funding that allows sufficient time to address those concerns.
Great, thank you, Eva. So I wanted to include this particular slide, which comes from the report, and I think Claire had included a link to the report, and you should all have access to that as well. But I just wanted this one pulled out because I think it's a really, and this one is Site B specific, but I should clarify that we do have this same data from all 3 sites that we evaluated, Site A, Site B, and Site C. I thought that this was a really interesting way of just making it concrete, what we're talking about when we're talking about time. And one of the things that really came across in every single site and with all of the attorneys who were part of the assessment was that the greatest challenge, when asked what their greatest challenge is in meeting the needs of their clients, the greatest challenge was a lack of time to adequately represent child and parent clients. And that's not unique to California. That's not unique to only this profession. But I think that what is really compelling about this particular chart and the breakdown is just seeing, when we talk again about sort of what standards of representation are, what quality representation is, recognizing that not enough time means not being able to meet the workload needs per client in these categories. And that's very, very significant when thinking about the legal interests and what's at stake in these cases. And so the MC column is minors counsel, the PC column is parents counsel. The MC and PC column is minors is for attorneys who represent parents and children. The total number in the data set is fairly low in that one. And so the columns that are probably most relevant on this chart are the first 2. But I think this is really compelling, again, to be able to look at the specifics here when thinking about the larger sort of role of counsel in these cases. So making a solid legal argument, making sure the client understands the legal options, whether that's a child or a parent. Spending time out of court learning about the case, having a strong relationship with other counsel on the case, having a strong relationship with the agency or volunteer staff, understanding related litigation. And this came up in the context of both criminal as identified there, but also immigration litigation, other types of cases that an individual client may be involved in. Understanding what services or assessments the client needs to complete. Visiting with the client, attending case planning meetings. And so when sort of looking at that category that Eva was just talking about what we found as finding 1, which is that funding did affect factors related to time, because it did mean, for example, in Site A, that with an increase in funding, there was a positive correlation with caseloads going down per attorney, which meant that attorneys had more time to devote to their clients and to meet these kinds of requirements. The flip is also true, which is that when funding went down, there was less ability to meet some of these timing requirements. And so I think this is just a really important way of highlighting kind of what time actually means. And again, to all of you, especially having seen the chat, and seeing so many familiar names, none of this is rocket science, none of this is new, but I think it is really helpful to have it documented and tied directly to the context of how it correlates with funding. Thanks, Eva. And so the recommendations that really came out, and when I'm speaking of recommendations here, it's the recommendations that came out from the assessment and from the report. Which will be a little bit different than what Leslie's going to speak to in a moment about recommendations of how you as direct practitioners can use the report. But the recommendations that came out from this finding were to make sure that when advocating for attorney funding, the goal is to have sufficient funding, levels of compensation to recruit and retain high quality staff. We understand that's not an easy thing to do, but again, having the data and having evidence from these different sites of how funding can impact compensation and things like recruitment and retention and turnover, and what that means for delays in cases and overall costs going up for the time that a case takes to conclude, is the data that we're excited to be able to provide. Also looking at how funding affects the ability to invest. I know I saw an Oklahoma reference in the chat earlier to having launched an interdisciplinary model of practice for parents counsel. The increase in funding, and certainly 4E, which has been explicitly tied to investments in that model of practice, did provide avenues for Site A to increase the funding support for social workers and peer advocates as part of the legal team. And then again, this funding level that allows for manageable caseloads and sufficient time to meet workload demands is tremendous.
So I will jump in now and talk a little bit about ways to use the assessment on the ground, either in your local jurisdiction with your legislature, with funders, any decision maker that impacts how your organization is funded or how your court and child welfare systems structure funding. Before I get to this slide specifically though, I do want to add one other thing to what Prudence was saying about time, which is that if you look at all of those activities on that chart, one might at first glance think, well, the lawyer said that they have time, the area where they have the least challenge is in making sound legal arguments. And that's our job as lawyers, is to make sound legal arguments. But if you look at all the other categories, none of those activities are throwaway activities. Every single one of them impacts our ability to do our best job in the courtroom. And more importantly, for the purpose of funding, it impacts whether cases are going to settle or go to trial. Attorneys that have more time to do investigation and prepare a case are less likely to end up in trial, because you have a better argument for negotiation and settlement when you have everything there in front of you. So cases will move more quickly, it will reduce court time. And when attorneys have time to work with their clients on complying with the case plan, accessing services, understanding their court orders, the families get their case needs met and again, move through the system more quickly. We get more kids home and into permanence and out of our system faster. So there really is a pretty easy argument to make about the importance of all of these activities and how they relate to funding. Similarly, when we look at the impact of compensation, for example, on recruitment and retention, again, it is not rocket science to know that if you can't give lawyers raises occasionally, or recognize their skill and recognize their expertise, they can't do the work, and they don't stick around. And I know, we hear again and again and again, especially from those of us who don't do this work, well, we know you're not in it for the money. And there's a difference in being in it for the money and taking a vow of poverty. And very few of us have actually taken a vow of poverty. We have families, we have obligations, we have burdens on ourselves and a need to live a reasonable life. There's a huge difference. And I don't think we need to be ashamed or embarrassed to say that to funders, that we need to be compensated fairly if we're going to be able to work at our best capacity. I know in California, and I imagine this is the same in much of the rest of the country, we tend to lose people to the county and to government jobs where they're still working in this arena, they're still in a service role, they're still working in child welfare, but if they can make twice as much and have 80% better benefits, at some point as their own children start to grow and as their responsibilities increase, they need to make more money. And it's not just worrying about the employee's standard of living. There's a real impact on our clients when we have high turnover and when we lose expertise. When the brain trust is drained, as it were, we're not doing as good of a job, and the amount of time and energy and resources, which translate to dollars that you spend on training, are an important part of the funding picture. Similarly, always tied to increases in funding is decreases in caseload. And when we have a decrease in caseload, we do our jobs better. And we also learn more about our clients. And one of the interesting things that we've noticed is that an immediate decrease, the immediate impact of a decrease in caseload might feel like an increase in workload initially, because we have the time to learn more about our clients and learn more about their situation and discover even more problems than we knew existed to begin with. But again, the long-term impact is that we're providing a better service, which results in fewer delays in the courtroom, fewer requests for continuances when we have a reasonable caseload, fewer disruptions in the court process, the ability to participate in multidisciplinary team meetings because we're not in court 24/7, and the ability to move a case and take care of attend to all of the activities that help move a family along in between court hearings are also significantly impacted, of course, by caseload. I think that's
great. Leslie, I'm going to chime in really quick before we go to finding 2 on just 2 points. One is to clarify, when we're talking about the caseload, we're really talking about obviously the client per attorney. And when talking about workload, we're talking about the amount of demands on time per case. And so looking at those as distinct, but obviously interrelated in terms of the question of when you have the more time available to meet the demands per case. And then the only other thing that I think is really important that we didn't hit on as much in the finding 1 is the case delays piece, which is that with turnover, with a lack of consistency in retaining attorneys, and also with an inability to backfill through colleagues and things like that, there's greater chances of case delays. And that has a huge impact, not only on the individual child and parent clients, but also on the legal system. And the swiftness with which cases can move, but also on the agency. And so hearing often from agency directors on that piece has been really compelling as well, to underscore how valuable it is for all parties to make sure that child and parent counsel is adequately staffed in order to not lead to case delays and to maintain consistency.
Thank you.
Thank you. Thank you, Prudence, for both of those points, because I think they relate directly to key finding number 2, which was that in addition to funding specifically for counsel, there are other child welfare system factors that influence the quality of legal representation. And so those do include agency policies. For instance, one of the sites had a change in agency policy to focus only on those cases that pose the greatest safety risk to children. Also, court funding and structure have a significant impact, and also client access to services. So just to give an example, especially because Prudence also mentioned the changes in caseloads over time. Again, just using sites A and B, in increased funding site A, you can see that with the increase in funding, the caseload numbers did go down. And so the red line represents the children's legal services provider, and the blue line is the legal services provider for parents. And so you can see with the children's, they did go down significantly, and the parents legal services provider also focused on increasing, making other changes within their organization, and so may have used some of that money for other purposes, and so the caseloads did not go down as much, but did go down over time. And if you compare that to site B, which, because the legal services providers changed during the time of the assessment, we did not have data from earlier in the assessment or in the assessment period. Only got the data from the current service providers. But even though site B is a decreased funding site, you can see that their caseload changed downward as well. And that was reportedly a result of that agency policy change in terms of focusing on the most complex cases. And of course that then, this presents the effect on caseloads, but as was mentioned, that also has a direct impact on workload in terms of the complexity of the cases that are on an attorney's caseload. So those are just 2 examples of how that finding played out in the various sites.
Thank you, Ava. And one other thing I want to mention about caseloads before I move into this slide in particular, back to the sort of how to use this advocacy. There are some very simple ways to share this information with decision makers. And one example, one thing we did in California is we created a poster. You've all seen the infographic where we had a picture of a lawyer, you know, it wasn't a real person. And then we had little people for all the clients. And anyone can understand that one big person with 250 little people, you know, and connected to them is not reasonable, is not manageable, and can't possibly be what quality representation looks like. So even without, and that visual was very impactful. We turned it into a big giant poster, and we walked the halls of the Capitol and got permission from most of the members of the legislature to put one on their door. So for several days, whenever anyone in the Capitol walked through the building, they saw this poster again and again and again and again, and it stuck with people. And it really, so there's things you can do that are simple, creative, and not expensive, and can be done with data that you have at your fingertips, because you know your caseload, you know your client load, you know how many staff you have, et cetera. So to Ava's point about sort of external factors and related factors within the child welfare system, there's a few important things to look at when we're talking about increased funding for attorneys. We also do want to look at the funding structure for the court, for example. So if your jurisdiction is successful in drawing down $40, for example, and you increase your workforce and reduce your caseload, but there are no additional court hours available because there's only one courtroom, for example, or you're in a very rural area and there's only one judge who is a circuit judge, who's only there 1 day a week or 2 days a week or whatever it might be, you may not see the same immediate impact in terms of timelines to permanence, for example. So it's important for structures to look at all the different parts and figure out how they can work together and where you're going to get the most bang for your buck. And it kind of, again, brings us back to what we do out of court and the impact that that has on what we do in court. I think one of the things we might be a silver lining of the pandemic is that in many jurisdictions, we're looking at alternative ways to get the orders that we need. So if, for example, you're successful in increasing your attorney workforce, but your judicial branch has a reduction in funding, as many states are seeing right now, you may want to look to using remote processes or filing more stipulations and changing local court rules to allow for certain matters to be handled on the documents if they can be done with agreement of all parties and it doesn't disadvantage your client in any way, but will help speed up their time going through the process. So those are important things to consider, and opportunities that have been created by our new facility with technology. Is this me again? Is this me? Yes. Sorry. So as we've sort of touched on from the Site B, agency petition filing practices can affect the total attorney caseload. If the agency is filing more cases, our caseloads go up. If they're filing fewer, our caseloads go down. Again, not rocket science. We've seen a tremendous increase in our caseloads in the past 6 months, again, because of COVID and lack of access to the courts, which is one of the things that really motivated looking for other ways to get cases processed. But also thinking about availability of services for clients. If our client has a case plan they can't comply with because the service is not available, there's a no reasonable efforts finding, and the case stalls and more time is added on, which really in the long run is not what any of us want. Just more time doesn't meet the child's needs, certainly, to get out of the system and back home as quickly as possible. And it doesn't, it adds to the, it compounds the damage done, it compounds the family's struggles and challenges. So including work with the agency and with other nonprofits and service providers to make sure that those services are available for clients is going to be an important part of advocating for increased funding for attorneys and getting their buy-in. And also demonstrating ways that we can help our clients access services. I think the parent partners and the peer advocates are especially important in this scenario because many clients, as we know, are reluctant to trust the agency. They're reluctant to trust those of us that wear suits to work every day because of generational experiences and community experiences. But when they have a parent partner or a peer advocate who can help them access services and work with them from their lived experience, it will help them make better use of the services that are available. And when those folks work in the lawyer's office, it really brings together the whole case plan and all of our advocacy. And again, turns out to be a cost saver as well, because paying lawyers at lawyer salaries to do things that perhaps a parent partner or peer advocate is better suited to do is an economy of scale that ultimately costs a little more for a lot more benefit. Let's see.
Thank you, Leslie. And so moving to finding number 3, we found that in addition to funding for counsel and those child welfare system factors, that there are also factors outside of the child welfare system that affect quality of legal representation. And so in our sites, each site, there were people who mentioned homelessness and poverty as significant challenges. And there were transportation issues and other issues that were outside the child welfare system itself and how they affected the quality of representation.
Great, thank you, Eva. So this one was really interesting. I mean, I think that the message that you're all getting here, and just to lay the groundwork, there's only 4 findings. So you're gonna, we're closing in on the final ones here. But I think one of the things that's really important is just that sort of trajectory of the findings, which is the number 1 is that money does matter, right? That money had a direct impact on factors associated with the delivery of quality legal representation, both in terms of increases in funding having a positive impact and decreases in funding having a negative impact on the ability to provide quality representation. The second is that money for parents' counsel and children's counsel is not the only variable within the child welfare structure, that court funding and processes, agency processes, availability of services, all of those child welfare related factors can also affect the ability to provide quality legal representation. And then this, which Eva just described, is a third component of that, which is that things that aren't directly within the child welfare field can also have a direct impact on the ability of children's counsel and parents' counsel to be able to reach levels of high quality representation. So for example, as Eva was just mentioning, transportation was a theme that came up repeatedly as a challenge, that if clients don't have an ability to meet with their attorneys, that criteria that we looked at earlier on, even if you have more time, if there's not an accessibility solution, if there's not a way for a client to get to an attorney or vice versa easily, that can have a negative impact on the ability to provide quality representation. Similarly, housing, the instability of location and housing definitely came up as a theme that would stymie the ability of attorneys to meet regularly with clients or ensure that clients can access services regularly. And that criteria doesn't specifically fall within the child welfare space, but does have an ability to affect the provision of legal services. And then again, immigration came up at least in one site as a theme because it affected the ability to access services in some instances and to be eligible for them, and also affected, and I think this is a theme that Leslie was just talking on, the trust, the level of comfort that clients had in seeking services and support. The sort of finding 3 and the recommendations of how to address them are obviously very macro in the sense that they're not even child welfare specific, but I think in some ways are also some of the most important findings to be reflecting on right now because of the pandemic and because of the fact that there are new elements. Housing instability obviously has become exacerbated to levels that we hadn't even anticipated at the time of doing the assessment. And so really recognizing how so many of the, and technology, accessibility of participation in court proceedings, that many of which have moved to remote technology, even if clients don't have ready access to participate or to participate in services, that those are things that aren't necessarily child welfare specific issues, but that have had a compromising impact on the ability to provide quality legal representation. And so this again is an area where it became quite clear in the evaluation, in the assessment, that this is an area where it's important to recognize money matters, but money is not the full picture of. Go ahead, Leslie.
I was just going to add, although these are areas that aren't specifically within the child welfare legal framework, one of the impacts of increased funding is it allows organizations to do more policy work because they have a little bit more time and they can look at things globally. And one way that played out in Los Angeles is that our parents' firm worked with our board of supervisors to create a pilot program that would allow for certain orders to be made, which had to be made in the dependency court in order to ensure that parents could be eligible for HUD housing the day that their children came home. There's some funny rules where you have to have your child in your care in order to be eligible for certain HUD supplements, but the court wouldn't release the child because the parent had nowhere to live. So there's this catch-22. And had it not been for the increased funding and the opportunity for the parents' firm to work with the county to develop a workaround to this federal requirement and still be in compliance with the federal requirement, it never would have happened, and it got more kids home. And so that it does end up falling within our domain when we need court orders in the dependency court to access federal services, for example.
That's a great example, really bringing it full circle. And so these were some examples of how to use the assessment and this third finding in particular to explain, similar to the example that Leslie just gave, to explain the connection between high quality representation and potential influences that are related, but not necessarily 100% in the lane of child welfare, including transportation limitations, housing access and stability, immigration status, and we should certainly add to this bullet the access to technology.
And that's also a very good segue to our fourth recommendation. So this was not a finding specific to the assessment, but it was something that came out of the process of the assessment itself, which really revealed that we need more robust data in each site. And by improving the data management systems and increasing the use of continuous quality improvement, we can look at those factors that affect legal representation and link them directly to outcomes for children and families.
So data, lawyers don't typically think about data. It's not, for many of us, not technology and use of data. Data suggests numbers, and we don't like numbers. That's why we went to law school. But there really are some important ways that data can help move our work along. In addition to, I think, sort of the first level, which is using that data, again, with policymakers and funders. But there's also benefits within your organization. When you have a quality data management system and are tracking the activities that are important to you as an organization and important to your advocacy, it gives you the opportunity to look and see if what you are doing is really what makes the difference. You may have beliefs within your organization that a particular activity is really the most important thing you do. If you look at your data over time, you may learn that there's some other activity that actually means more to your clients than the one that you think matters to them the most. It also is very useful for managers to be able to work with their staff on looking at how they're spending their time and are they efficient, are they effective? What might they want to do differently in order to relieve a workload stress, for example? And also, not every court system collects great data, and sometimes the data we collect may be different than the data that the county or the court system is collecting, and comparing that data may provide some really interesting insight into what's happening in your system and open the door to better collaboration, to working with your agency and your court to make changes that will be beneficial for everybody. And then I think on an even more, on a third level, I don't know what it's more of, but we recently, for example, changed our practice regarding collecting racial and ethnic background data. For 30 years, we've relied on whatever the county has put in the report. If the report identifies the child as African American, as Latino, as white, that's what goes into our system as well. And we realized not that long ago that that data is typically based on a social worker's observation, which we all know is not necessarily an accurate way to quantify an individual's racial or ethnic identity. So we began this process of asking our clients, how do you identify? And it turned out that some staff were very uncomfortable with asking the question, not because they didn't think it was important, but because they didn't want to do more harm or put or have an awkward conversation with their client, we very easily found that there was a bunch of information out there written by child development experts and others about easy ways to talk with children about race. And we've now implemented that, and it has this really beautiful unintended benefit of opening up conversations where our clients really feel heard. Their attorneys are learning things about their clients they might not have otherwise learned in the course of a typical client conversation. And we're going to have this really rich data to look at down the road so that we can evaluate our own work with reducing and eliminating racial disparities and disproportionality, which are so important in the child welfare system. And our data may end up looking very different than the county's data or the court's data, and I think will be extremely useful down the road. So there are many different ways you can identify in your jurisdiction what's important. Maybe zip code is important, maybe what school they go to, maybe what part of a very rural area they live in. There's so many different ways that the data and management, data collection and management can help you improve your practice.
Great, thank you, Leslie. And so just to go over what we have covered today, what we've been able to talk about was the background and methodology for the assessment itself, our 3 key findings and 4 recommendations on the direct effects on staffing and time, on influences within the child welfare system, and then factors outside the child welfare system, and our recommendation regarding data. We also covered how to use the assessment report in advocating for quality legal representation. And so based on what you've heard, we would like to ask you to please join us in a discussion of these findings and recommendations. And again, if you want to put your questions into the Q&A, then we will be able to answer as many of them as possible before the top of the hour. And I'm going to go ahead and ask Claire to pull those up for us and let us know what people are asking.
Yes, we have a number of questions. Thanks to those of you who have been writing and providing thoughtful questions. The first question for the panelists is, would using 4E funds highlight disparities across states for how much attorneys are billing for 4E cases? Would it lead to audits? Some states achieve permanency in under 2 years, and some are terrible at it, and funding might draw attention to that.
I will jump in on that, and I would say great. That would be great if funding drew attention to that, right? I mean, if there are transparency, I mean, no one wants an audit. Nobody welcomes an audit, but transparency in funding is how we get to equity in funding. And I think that we need to, as a profession, not shy away from that and instead welcome the scrutiny. It was the first couple of years of the steps that were taken in California to eliminate the disparities in funding county that were apparent county by county, where some counties were funded at a much greater percentage of need than others, was very painful the first couple of years. I would be lying if I didn't acknowledge that. But now we have a situation where we have statewide collaboration that we have never had before. We talk very openly amongst all the various attorney groups about what our needs are. We learn from each other in ways that we never did before. And we are able to advocate collectively across the entire state instead of pitting one county against another or one organization against another. And the result has been significant increases in funding. And really interestingly, because we worked so hard with so many legislators across the entire state, when our budget statewide was cut, when the entire California budget was reduced because of COVID, the legislators told the governor, no, we're not cutting pay for dependency attorneys. And we were flat funded when most of the rest of the state had a 10% cut. So I would say that even if looking at funding does reveal some inequities, you use that to your advantage to raise up those that need to be raised up and hold accountable those that are not meeting their clients' needs.
And I do think, just to build on that point, Leslie, for a second, to take it, look at the California approach and think about that in a broader sense. I think it's really interesting that the goal when the reallocation of funding was first determined in California was that the goal was to make sure that every county is in some level of equity in terms of percentage of need met, recognizing that none of them are meeting the percentage, right? That like no one is at, that there's a parity in trying to aim for that same number, that I think helps to underscore the importance of looking at this as a transparency and not as sort of a just money itself, but really the need met being the criteria that is the end goal.
Great. And another question, did the study treat macro change in funding available per county as proxies for level of funding made available to specific or individual attorney, or caseload change, or other on-the-ground change?
Right, so I will take that one on and say that, yes, so we used funding in terms of determining the increases in funding and the percentage of need met. We used the overall funding. But as I mentioned earlier in the description of the assessment, we did identify those counties where there weren't other influences in funding, where there wasn't any backfilling. If there was a decrease, that there weren't others who came in and filled that decrease. And so we did use it to indicate, you know, what that funding was for the site as a whole, and was limited to just that funding for that site. But we did not go deeper into what the specific contracts for the legal services providers were and how individual attorneys are compensated.
Great. And there's another question about how was the need determined within the localities?
So, do you want me to take that one?
Or Leslie.
Okay. So the Judicial Council conducted a study that looked at cost of living, the median salary for county council, and a few other factors. It was and came up with a very complicated formula that essentially set, oh, and I'm sorry, and looked at time also. They did some time studies and some focus groups with lawyers and came up with a formula that determined how much it should cost to provide competent representation per client. And then every year they do, they look at the number of children in the child welfare system and divide that statewide and countywide, and that gives the need for each county. So it's based on time, cost of living, and number of children in the child welfare system. It's a very simplified way to explain it, but it gives percentages and proportions for the entire state of how much funding each county needs to fully fund their dependency attorneys. And we're not there yet. I mean, none of us are, no, the state is not fully funded, but we are at a better rate than we were 5 years ago.
Great. The next question is, do you have any advice for convincing the legislature not to see 4E funds as a cost-saving tool?
I see Leslie smiling, but I'm happy to take this one first and then let her jump in. I'll take it out of the state context for just a minute. I mean, so if you go back actually to that infographic, there's a reason why we put cost savings as the last bullet point on why it's important to invest in quality representation. And it's not to undermine the reality, which is that in the long run, ensuring that children and parents have access to high quality representation is a benefit financially for the larger child welfare system, but that's not the real reason to do it, right? And so I think that to the extent that legislatures right now, there is a risk of seeing drawdown of 4E funds for attorneys and having that be a reimbursement to plug holes in other aspects of the budget that are challenging right now. I think real main message is to go back to why those funds were made available by the federal government 2 years ago, which is because these are really important cases and these are really important rights at stake for children and for parents and for the community, that the outcomes are better for the individuals involved when children have access to high quality counsel and parents have access to high quality counsel. Regardless of cost savings, that is really important message. And that is the underlying reason why that policy manual change was initiated.
The only thing that I would add to that is I would ask my legislature if you think we're well funded now, if we believe that we have the system that we want and the model that we want, then we could talk about cost savings, and no one can say that. So it's maybe a risky question, but certainly one, if it's being answered honestly, cannot be answered in the affirmative. Can I jump, because it's all connected? There's another question. We're all counsel, regardless of role, equally compensated within the locality, and the answer is sort of similar to so all parents and children's counsel are equally funded, yes. Does that mean, because it's again based on that per client calculation, but does that mean that individual attorneys are similarly compensated? Not necessarily, because that depends on the decisions made by the contractor. So by the organization that represents the kids or the parents, or the law firm that represents the children or the parents. And one of the things that I think is very important to consider is that, or to know, is that in California, for example, we have a right to counsel for parents and kids, and it's statutory, but minors counsel also have a statutory obligation to see all of our clients at certain timeframes. And for children, much of that contact has to take place outside of court. Seeing a 1-year-old in court doesn't offer much help. So we have to go visit all of those kids in their homes. So as a result, we have an expense that parents counsel don't have. Granted, our CLC is the largest in the nation. We spend $750,000 a year on mileage alone. And we have to hire investigators and case managers and social workers at a much higher rate than the parents counsel have to in order to meet our statutory obligations. So even though the overall funding is the same, it doesn't necessarily translate to salaries being exactly the same. In some jurisdictions it is, but not in all.
Great. Thank you so much, both Leslie and Prudence. And I just want to note that we have reached the top of the hour, and I know there are some remaining questions. And so I think we'll take a look at those, and if possible, put the questions and answers to them up on our website. And so to that end, I just want to draw your attention to some of these resources. So you can find the full report and summary and relevant additional documents, including these PowerPoint slides, on our CalRep funding website. And then we encourage you also to visit the ABA Center on Children and the Law website for all sorts of resources related not just to quality legal representation, but some of the other areas that Prudence mentioned earlier. Also draw your attention to the Family Justice Initiative website. FJI has a lot of information on Title IV-E and how to, and follows that closely in terms of what states are doing and provides some guidance there. Also want to recommend the Capacity Building Center for Courts. And then finally, the Capacity Building Center for States, along with the Children's Bureau, put together a video for the webinar, Collaborating with Courts to Promote Foster Care as a Support to Families. So Claire is putting this information into the chat as well for you. And as I mentioned, you can find these PowerPoint slides on the CalRep funding website. And so we want to thank you all for joining us and hanging with us for a few minutes past the hour. And just want to thank you. And we look forward to working with you on these issues in the future and making sure that this assessment is useful to you as practitioners as well. Thank you.